All right. Good morning, everyone. Thanks for being here. The panel that will soon start is going to be around two main topics. The first one is a quick recap of where we are at with dual use regulation. But the main topic that we'd like to cover here is what have we learned from this experience, both with the European Union and partially with the Wassenaar Agreement in general, and how can we work together better with the governments and also other civil societies, member like Privacy International. I'm really happy to have this esteemed group of panelists. We also have one person that you cannot see because she's in Brazil at the moment. So I'm going to start with her just to go through the bio first, and then we'll show a brief video from Ms. Shake, and then we'll start with the live panel. So first panelist, Marietje Schaake. She's a member of the European Parliament for the Dutch Democratic Party, and she's also with the Alliance of Liberals and Democrats for Europe. She's the coordinator for the International Trade Commission within the Alliance of Liberals and Democrats for Europe. She's also the spokesperson when it comes to for the same group when it comes to transatlantic trade and investment partnerships, also known as TTIP. She's served on the Committee on Foreign Affairs, where she focused on improving Europe as a global player. She has a pretty significant interest in human rights. She worked a lot with Turkey, Iran, North Africa, and in general the Middle East. Within the scope of the Subcommittee on Human Rights, she coordinated monthly human rights resolution for her political group. And she is the vice president of the delegation for relationships with the United States. What else is she? Oh, she is a World Economic Forum Young Global Leaders and a member of the European Council of Foreign Relations. Then we have Mr. Paul Timmers. Paul Timmers is the director of the Digital Society Trust and Security Directorate in the European Commission Communication Networks, Content and Technology Directorate General, also known as DG Connect. He deals with policy and R&I in ICT, health, aging, public services, smart cities, and cybersecurity. Before adding the directorate, he added the ICT for the inclusion and the e-government units. He was also a member of the cabinet of the European Commissioner for Enterprise and Information Security. Before joining the European Commission, he was a manager in product marketing and software development at a large IT company. He co-founded a software startup, and he holds a PhD in theoretical physics from the University of Nijmegen. I'm sorry, I botched this one, and an MBA from Warwick. He has been widely published in the field of technology and policy, including a book on electronic commerce strategies and business models. He was a visiting professor and lecturer at several universities and business schools across the world, including the EU and the University of North Carolina in the US. Then we have Dr. Richard Tynan. Richard is a technologist at Privacy International with a specific focus on the area of surveillance technology. He focuses on wired and wireless surveillance mechanisms and the strategies employed by cyber criminals to harvest valuable private information from a wide range of ubiquitous devices such as cell phones and personal computers. Richard holds a first-class honor BSc degree and a PhD in distributed artificial intelligence for embedded sensor network from the University College of Dublin, and he has also completed a graduate diploma in law. Then the last person we have on the panel is Thomas Dullien or Arvo Flake, depending on whether you've been attending Black Hat for more than 5 years or not. So Thomas used to run a company called Dynamics. The company used to build reverse engineering tools. Company got acquired by Google. After the golden handcuffs period, Thomas is on a year-long sabbatical trying to learn how to surf, if I recall correctly. And then myself, I'm on the review board of Black Hat, which I guess is the main reason why I'm here. And I'm going to moderate the panel for the most part. So the first thing I want to do is to show Mariche's video. She was really kind in making sure that she could do this, even though she is in Brazil at the moment. Let's see if I can get this to work.
Good morning. My name is Marietje Schaak and I'm a member of the European Parliament with the Dutch Democratic Party D66. We're part of the Alliance of Liberals and Democrats for Europe. And as you're watching this, I'll be in Brazil to attend the Internet Governance Forum, and that's why I could not participate in the Black Hat sessions in person this year. But I'm happy I can share some of my thoughts with you through this video. In the European Parliament, I serve on the committees for Foreign Affairs, International Trade and Human Rights. And I've been actively working on the reform of the EU's dual-use regulation, but also on the EU's export control regimes. It is often said that politicians don't know much about technology, and it's probably true in general. Some don't know the difference between a server and a waiter. But I would also ask the question to you, how much do security researchers know about politics and lawmaking? I welcome the opportunity to exchange ideas between the worlds of technology and politics. So let me begin by clarifying some misunderstandings on what the EU plans to do and what the intention is behind the review of the dual-use regulation and how all of this affects the work of information security researchers and the whole community. Firstly, in none of my efforts would I want to stifle the work of independent security researchers. I've consistently said this throughout the years that I've been working on dual use and other export controls, and I've also made it clear in the reports that have been adopted by Parliament. Secondly, I do not want to ban the trade in 0 days by using the review of the EU's export control policy. This has never been the intention of the review process of the dual-use regulation, nor are export controls the ideal way to regulate the sales of 0 days. This was very clear at an event that I organized last month in the European Parliament, in which Vincenzo and also other security experts spoke, representatives from the European Commission, from NGOs and the European Parliament. I thought it was a good and lively debate. But to be clear, it doesn't mean that I think we should leave the regulation of this market entirely up to industry. States and governments have the duty to secure citizens and their rights online and offline, and certain aspects of the trade in 0 days cannot be left unregulated. In the future, the EU could look, for instance, into coordinated disclosure initiatives as a remedy against the abuse of software vulnerabilities and data breaches. This is now a discussion, but there are no specific EU policy proposals on the table. What is being discussed is that human rights considerations should play a larger role in the decision process of export control authorities on whether or not to grant licenses. Until now, you needed a license if you wanted to export goods outside the EU that could be used to the detriment of the EU's security. For example, goods that could be used to make a nuclear bomb. Surveillance, hacking, intrusion and exfiltration systems are a relatively new addition here. The EU's policy needs to be reformed in order to ensure that certain dual-use items, including ready-made surveillance systems, are not marketed, designed and sold to authoritarian regimes. They use them to spy on journalists, human rights defenders or opposition figures. And human rights should be added in the EU regulation as an extra control criterion. Now, in the absence of the right regulations, the EU's credibility as a foreign policy actor is severely damaged. We cannot criticize human rights violations in Uzbekistan, Russia or Sudan while we continue to allow European companies to sell the same technologies that enable these very human rights violations in the first place. Another important element of this review process for me is to get more transparency, effectiveness and coherence in our EU export control system. Currently, it is not very clear which EU country stops what type of good, and there is no uniform interpretation of the EU rules, and this needs to change. We also need to make sure that the rules are uniformly applied and that we have a level playing field and effective controls. To make sure that we target wrongdoing and not legitimate activities, I focus on the trade transactions and the context within which systems will be used, not only on the technological specifications. On my website, you can find 12 concrete actions to remedy human rights shortcomings in the EU's dual-use regulation. But for the purpose of today's event, I will only focus on 4 of them. First, I suggest that the Commission should set up and provide so-called Know Your Customer guidelines that give instructions to companies to assess whether their dual-use items, including intrusion software, may be used for internal repression or human rights abuses. These guidelines can consist of a checklist of flagging criteria that could indicate potentially suspicious transactions. And on this basis, companies can assess the plausibility that their products may be used to violate human rights before the sale is actually completed. And the Commission in turn should monitor enforcement of these Know Your Customer rules. And whistleblower protection should be offered to employees of exporters that report non-compliance. Second, I suggest that the Commission should be able to swiftly provide companies that are in doubt as to whether to apply for a license or not with accurate and up-to-date information on the legality or the potentially harmful effects of their future transactions. To this end, a company help desk should be set up, which should closely liaise with EU member state export control authorities to provide companies with the necessary information. A third issue focuses on modifying the definition of intrusion software as a controlled good in the EU's export control regulation. I'm very much aware that there have been a lot of concerns about this specific definition, especially because there exists a varying degree of interpretation of which definitions cover what technologies in national implementation regimes of the Wassenaar Arrangement. Now, in order to remove the unintended chilling effects that this inclusion could have on the work of security researchers, the Commission should clarify that the scope of control on the development of intrusion software applies only to end-use cases and end users facilitating or conducting surveillance and other human rights violating activities. Now, my last proposed action that I'll mention today is that I call on the Commission and the relevant export control authorities in the EU member states to engage in a permanent dialogue with security researchers. An appropriate framework for this is the Surveillance Technology Working Group within DG Trade, the dual-use working group. While controlling the export of technology to prevent human rights abuses is essential, export controls should never hinder the legitimate transfer of technology which can be used to protect human rights or that are used for research. Now, since I know that you appreciate clear language here at Black Hat, I will add one more thing to my list of recommendations, and that is that the information security community needs to get its act together. Right now in Brussels, the so-called cybersecurity community consists of large companies whose interests aren't always aligned with what a number of you may want individually. And I know that there is not one uniform opinion in the research community either. But if you want to prevent unintended effects of legislation, it helps to be a part of shaping it in a constructive and active way. And your technical expertise is needed, even if it is impossible for everyone to agree at the end. I hope this introduction and some of my points will lead to a lively discussion, and I really look forward to learning more about what came out of your conference today. Thank you. Hope to see you in person soon.
Okay, so as I mentioned at the beginning of the panel, we have 2 goals here. The first one is to do a brief review of what we've learned so far and sort of like understand where we are in terms of regulation. But then the main goal here is to to figure out what to do in the future, understand how to work better with the institutions and civil society. So I'll give you a very, very brief recap of where we are with this, meaning dual use regulation. So there was a consultation period with the European Commission that ended on October 15th. The Commission is supposed to come up with a proposal by the end of Q1 2016 for the Parliament. The proposal will be discussed within the Parliament by the appropriate Commission. There will be amendments potentially, and after that there will be a vote. Then it will go through a discussion in the Council, a discussion between the Parliament and the Council, and then, assuming all of this works out, the dual-use regulation will be replaced. Now, one other thing that is important to understand about dual-use regulation is that it's not just about intrusion software. The main goal here is to sort of like shift, or at least the main goal of some of the actors involved in the regulation is to think and shift potentially the idea that dual use should just be about national security and include the concept that dual use should also be about human rights. The other thing I want to say really briefly is that there's been a lot of confusion between what's going on in Europe and what's going on with Wassenaar. Wassenaar and this regulation are not related. The European Union has no bearing in what Wassenaar decides. Wassenaar is a group of 41 countries where you have members of each individual country, usually the equivalent of the DoD or Ministry of Defense, and they discuss topics that are sensitive in terms of national security. What happened here is that the timing was not great, and so as Wassenaar was being implemented, also the dual use review happened, and that's why there has been a mix-up in terms of the role of the European Union with Wassenaar. So I'd like to kick off the panel with I think the main topic that Ms. Schaake brought up, which is, do we think that human rights should play a role in the regulation of cybersecurity, or should it just be about national security and commercial interests? I'd like to start with Rich on this.
So one of the things in relation to the human rights analysis seems to come a little bit after many of the controversial measures. So at least in the UK and many of the other EU states, a technology that meets a certain definition would then, if it was to be exported along the lines of either an actual transfer of code or the transfer of knowledge. So for example, teaching somebody about intrusion software, things like that, that would be called a deemed export or an intangible technology transfer. And I think the question that we're asking here is not whether that should inform after somebody has applied for an export license. And I guess a lot of the main pushback has been from the fact that many of the technologies that need to circulate freely to improve security may now be caught, which would potentially require individuals to, even as Marietje said, even if Marietje's proposal was correct, even pick up the phone and call their government. And I'm not sure that is the right process where an individual who's playing around with stuff and finds something and wants to disclose that would need to, in effect, get permission from the government. I guess just a note of clarification, are we talking about human rights in respect of informing what goes into Wassenaar and the EU dual use, or is it human rights in respect of the decision of the export control authorities about whether to grant the license in the first place?
So I was thinking about it more in like broad terms, meaning in general, we eventually, and it's happening already, cybersecurity will be regulated more and more, right? And a lot of the things we do in this field potentially could be used for human rights violation.
Yep.
When it comes to regulation, should that play a role, in your opinion, or not?
I think absolutely it should play a role. However, I don't think, firstly, I don't think 0 days, and I'd like to understand from Richard what she means by regulating part of the 0-day market, what that actually means, because I'm not sure any regulation in the respect of, for example, proof of concepts, vulnerability disclosure, I'm not sure how that would encourage or facilitate the free flow of vulnerabilities to the people who need to actually know them, if there is this barrier to apply for a license before it's exported.
Okay. Thomas, what's your take on this?
So, is the microphone working? Yes, it is. Okay. So, I guess the entire idea of having human rights considerations influence regulation, that sounds really, really nice on the surface. When it comes to technology, it gets really fickle very quickly because so much of technology can be used for surveillance, right? Image recognition is a facial recognition software in itself something that is going to be used for surveillance. And given the interconnectedness of technology, very quickly you end up with almost everything being somewhat, like, at least falling under the definition of being able to be used for surveillance. So we go, like, database software. Everybody knows Oracle was originally a CIA project. So is an SQL database inherently something that will be used for surveillance? So in general, I think it's a good idea to try to use regulation in order to encourage respect for human rights abroad. Mm-hmm. But it's very difficult once you roll that over to a responsibility of industry. Right. Because an individual company can't make the call whether another government is authoritarian or not. Right. Because these are political statements. And even if you say, well, a government is authoritarian if people on its territory don't have voting rights or something like this, you get a lot of really complicated questions. Industry can't answer these questions, so whatever regulation happens, there needs to be a very clear path to follow, and then there needs to be a consultation with people in the industry before regulation happens. Because what happened with Wassenaar is consultation didn't happen, and now we're trying to limit the fallout, and that's not ideal.
Yeah, I mean, especially from, again, and I want to talk about Ms. Schake's proposal because Ms. Schake is not here, but one thing that I've seen repeated over and over again is this idea of trying to have controls like know your customers, and the problem, like, it seems to me that one of the attempts that is being done in terms of regulating the sector in general is to have a very similar regulation to in cybersecurity that we see in finance. And the problem is that we will have the same problems that we have there. So we will still have HSBC laundering money for some Mexican cartel. We will still have some prosecutor thinking that one thing is insider trading where it's actually not, and so on and so forth. So I think that is just shifting the problem. And I think the one thing that we as an industry, and it doesn't apply just to cybersecurity, it applies to tech in general. What we have is the ability potentially to codify some of this in a way that leaves little room for interpretation, and I think we're not there yet. And one problem that we have is probably the lack of proper interaction between the parties involved.
One short note on the know your customer. The implication of know your customer, I mean, it sounds very plausible on the surface again, but the implication of know your customer is if you're giving a training at Black Hat, you would have to know a lot of background about everybody that attends. I'm not saying that's impossible, but out of a sudden there's a lot of bureaucratic involvement with just something very simple like training somebody to use Metasploit or something like this. So, and I used to run a small company that was selling reverse engineering software, and we had a lot of business in the US, and at some point somebody from the US told us that we can't tell you whom to sell to and whom to not sell to, but your selling decisions affect our buying decisions. So clearly we tried to have something like know your customer, which then led to things where a particular government that we thought we didn't want to sell to ordered a large software license, and we're like, we can't sell to you. A week later, a Hong Bin Imen Export in Canada sends the same order in. And then we're like, oh no, we can't do that either. Then 3 months later, an architecture student in Australia who was born in the country that we didn't want to sell to sends the same order again. And this just escalated over time, which means that know your customer has limits in the sense that you can't turn your company into a private detective agency that tries to track down everything.
I'd also just follow up on two things. One is that while database software and image recognition could be used for various things, in the majority, all export control law that I've seen, particularly in the EU Wassenaar level, there is a clause which I'm not sure adds any particular clarity to it, but that the system must be specially designed or adapted for whatever X is. Secondly, the training issue is very, very important in terms of educating somebody. And I'm not even sure know your customer, the end customer, is necessarily determinative in terms of what that will be used for. So for example, a piece of software that one might actually, I mean, this all started with, say, Finfisher, Hacking Team, that kind of stuff. If even a government was trying to get its hands on this for defensive purposes, so that it could see the pattern of exfil, it could see various, put in place various firewall measures to actually try and detect if they've been infected. That adds an additional, I think, layer of problem on top of the actual knowing who the final customer is and the responsibility on companies to know the customer.
So I'd like to broaden up a bit the scope here. So Ms. Schake asked a rhetorical but very interesting question in the message she sent us, which is, how much do security researchers know about politics and lawmaking? And I think it's a very important question to ask ourselves, and also to get somebody else take on it. So I'd like to start with Thomas and then Paul on this one.
So I can safely say that I learned more about lawmaking in the last 6 or 8 months than I ever wanted to learn. But it is a problem, right? Because Haroon's keynote was very, very eloquent in telling us how deep of a hole we're in technically. So everybody's really busy trying to get the technical work done, which means nobody engages with what is happening on the lawmaking side, which means it's the defense contractor lobbyists and a few lobbyists from a few large companies that get to influence lawmaking, and they have different priorities from the security community. And also, security is very fragmented, meaning we have a lot of relatively small companies in comparison to many other industries, which does not help when you try to make your voice heard. So all in all, I think it's a problem, and we need to somehow fix it, but I am not the only one that would say I can't be the one that fixes it, right? It's a bit the tragedy of the commons. Nobody has time to engage with it, and then everybody gets hurt by nobody engaging with it.
Paul, what's your take on this, being on the other sort of other side of the table?
I think it's certainly a challenge, and it's not a good thing that there isn't a close interaction between the security research community and the policymakers. Perhaps to illustrate a little bit, in my own field, I'm heading a team which is doing policymaking in the field of cybersecurity, and it's mostly oriented towards resilience. The economic and societal use, the continuity of that has more an economic dimension. So less actually the issues around export controls and those kind of things, not so much important that. And then we've got a group that is doing support for technology development, and they are also doing, of course, a lot of scanning, and they try to stay involved in what are the current developments. And the interaction between these two groups alone was already, and this was inside the commission, it was already not good. So we reorganized in 2012 and said we put these two groups together. So that is very interesting, but it puts really the challenge, I think, like you point a little bit, you have to have people that understand technology, that really, really learn about what it means in legal or policy terms, and the other way around. And let's be honest, not everybody will be able to do that. So you also need to organize for a discussion and a dialogue. And while we are trying to do that, at least in part of the commission, and we do it also actively with our colleagues that are responsible, for example, for DG Trade, and more into the export controls or external action service, I think we should really get it better organized also between the communities. And I think it can really deliver a lot. I mean, although we are often perhaps on relatively long timescales, like with regulation, I mean, the example that you take will certainly take quite a while before it's fully discussed in Council and Parliament. Although when we support financial investment in research and innovation, there are also the timescales are relatively long because it's bureaucratic procedures, it's public money that is being spent, so also has to be all properly accountable. So for sure we are good in red tape around that. It takes long. The actuality or the what is actually happening in the cybersecurity field is very, very kind of punctual. I have to answer every other few days something for the politicians about what is happening in the field. So we need to also have that knowledge on our fingertips and be able to talk to people that have it right away available, and that you have to organize for that. Yeah.
Yeah, so one interesting thing about this is that, so another field I'm sort of interested in is Bitcoin related things. And I was talking to a lawyer who turned into an advocate for Bitcoin. And the discussion we were having is it more likely that we can have lawyers that understand tech, or is it more likely that we can have tech people that understand law? And we couldn't really agree on that. But I think I guess the interesting problem here is, do we actually think that we need those figures, or do we think that it's just a matter of having sort of like translators or interpreters that can translate technical concept to policy people and vice versa?
Also, I'd just pick up on a couple of things there that we're seeing an increasing trend to the politicization of IT security. And growing up, IT security was all about the tech. And we're now seeing, for example, governments engaging in hacking, and whether particularly in the UK, we just passed a bill that permitted the UK government to hack pretty much anything, anywhere, anytime. And this pushing IT security or cybersecurity into the political domain, while maybe okay in one respect, I'm not sure that the overall benefits to the actual security and privacy of systems. And again, I'm happy to be wrong on this. But the other point as well is that I think security work is a niche area and it's hard enough without having to also be familiar with a significant amount of legislation, and not just the legislation as is written. Because for anybody who's been following the debate, the Wassenaar Arrangement has been clarified, whatever that means, in the UK and the US. And while we were told that this wouldn't include 0 days in the US, it did include 0 days in terms of disclosing them. So I think at the very outset, the legal framework needs to be, if regulation is to be introduced in this area, it must be clearer than any previous piece of legislation I've ever read, in terms of having somebody who doesn't, for example, even understand the notion of, say, separation of powers, rule of law, how the Constitution would regulate things, various different rights, freedom of expression, things like that, so that they don't have to go digging for cases on how an individual law is transposed and then interpreted, because I think it's just a different skill set, right? That how you deal with a computer system is very, very different to how you need to familiarize yourself with the implications of a law and how it ultimately gets interpreted by judges, and then various different precedents and how they interrelate to each other.
I think you're touching on an important point, which is particularly relevant in Europe, due to the fact that every nation implements their own version of a guideline. The European market is much more fragmented legally. What happens a lot of times when we dealt with reverse engineering, we try to get legal advice on whether a particular reverse engineering act for security is legal. And usually the lawyers told us, well, the law for this has never been tested in your jurisdiction, so we can't tell you. And this makes the situation worse in Europe, because any law that is implemented, most likely you happen to be in a country in Europe where it hasn't been tested yet. So the interpretation of that law is even not clear to domain experts.
Exactly, and I mean, if it's not clear to people who are experts in export control law, they've lived and breathed it for many, many years, how can we expect people who don't have a legal background and don't have these kind of this trained eye for these various things to understand it. And this brings in then the notion of chilling effect of, well, feck it, I just won't do it. And I guess that's one of the major concerns around it.
Sorry, a lot.
But just briefly reacting. One is that you absolutely have to be close to these processes because they're going to happen anyway, whether we want it or not. Whether it leads to something legislative is a separate question. Policymakers will anyway, and politicians will anyway have a view on it, whether it's actually making sense in terms of law or technology at all. So politics plays an important role in this. But then I think it's absolutely essential that once people are starting to design, let's say, guidelines or legislation around it, that there is that really, really well-informed test against what does it mean in technological terms and vice versa. Because I agree with you, it's easy to write down. It's easy to write down, let's do security by design, privacy by design. So what actually? And so that's at the political level. Let alone that you write it in law. Okay, make it happen. And what are the unintended consequences of that? So unfortunately, perhaps we have to be very close to it from a technological point of view.
Mm-hmm. And this is interesting that I've never read a law, I've never heard lawmakers in any, I study law in Ireland and in the UK, ever mention this term unintended consequences. I'm struggling to understand who sees these consequences as unintended. Under rule of law, you need to be the law must be foreseeable. It must have the necessary precision. And if a consequence actually occurs because, for example, a judge deems it to have occurred, is it unintended? There doesn't seem to be the level of debate to tease out what these unintended consequences are so that the lawmakers, policymakers can be fully informed, so that in reality, the amount of unintended consequences is very, very small. And I think a lot of people online have voiced or have demonstrated consequences that while it may not be intended by the individuals in terms of what they're doing, their interpretation of the law, which is equally valid because they're the ones who are going to be doing it and potentially not doing the security research, that notion of unintended consequences doesn't seem to, I'm unable to kind of get my head around that as a concept going forward. But that's probably just...
So can I interject on this? So I think, one of the core topics that we're discussing really is about, again, communication and sort of like making sure that everyone has as much of a full picture as possible. Now, in the US, and this is like an interesting debate whether it's actually working or not, but one of the concepts is to try and have small programs that are funded by agencies like DARPA that both fund universities and also small companies and individuals, with the idea that besides reducing sort of like bureaucracy within the government and so on and so forth, one of the potential positive side effects is to be able to have like a funnel of talent from the technical side of things that can be used whenever something on a policy level needs to be discussed. So I guess my two questions here are: one, do you think that having some kind of structure like that in the EU would make sense? And if so, do we think that it's feasible?
What structure exactly?
So are you familiar with DARPA's like cyber fast track type of programs?
Yeah.
So my personal take on this is that up to a certain extent it works, in the sense that it does, like you do have a connection with certain parts of the government that then they can send you an email and say, we are discussing this piece of legislation, what's your take on it? And as far as I can tell, there is no such link in Europe. I would like to get your collective takes.
So me jumping in, sorry, but my worry would be, I've seen more than one company in Europe whose main product is writing grant applications for more European Union money.
Right, which is sorry, but that's one of the problems, right? So an application for something like the cyber fast track takes you about a day. An application for like a bigger grant, both in the US and Europe, takes you months. So that
I guess what I'm saying is that it may not be necessarily the right avenue to use the funding of research as the policy outreach, meaning that those may need to be separate things, but I don't know.
Okay. And I'd agree with that, but I also think in addition to, so Wassenaar in general is implemented in the EU via regulation, which then becomes effective across all the countries, and then they can have some implementing clarifications and measures in their own national law. To the best of my knowledge, there was no or little of that kind of outreach in relation to the Wassenaar arrangement on intrusion software, on IMSI catchers, on IP monitoring tools. So I think maybe we'd be in a better place if both the EU, Wassenaar, and including the US would have some sort of process by which concerns could be raised and could be raised publicly, so that but I don't know how you could figure out which concerns get taken seriously and which don't. Of course, that's probably the politicians that decide.
Perhaps I can make two concrete proposals. One is we are working on what is called a contractual private-public partnership in the field of cybersecurity. The intention is actually to be stronger as Europe in our industrial capacity. I mean, it's really about that. So it's not covering the world and everything and all the topics that you can do there. It's about that. But related to what you can do as companies and also as cybersecurity researchers, perhaps from a more industrial point of view, are all kind of other issues that have to do with development cycles, innovation, systems, who's working together with whom, standards, certification, what have you. We are going to launch at the end of this month a public consultation on that. So that's an immediate possibility to provide feedback and input to that. It's a bureaucratic process, but that goes relatively fast. So, and it's imminent. The second is we will have quite a lot of discussions around forming this partnership. And my invitation would be that also the cybersecurity, the security research community is part of that. And so, coming back to your suggestion, can you have something, DARPA fast track is over, as I understand it, and so we need to look at it also, how did it function and why. But would it be possible to redefine the research agenda in Europe and some of the tools? Probably yes. So is it going to be a very rapid scheme like the one day? I'm convinced not. So that's but perhaps someone else sees an opportunity in that discussion and says, well, I'm interested in supporting that. So it doesn't need to be all EU funding that moves into that. Perhaps the Finnish government is interested in it and takes it up to do that much more rapidly. Fine. So important is, I think, that we have a fairly concrete policy development going on. It's not legislative. It's about this form of research and innovation, and it should deliver ultimately by the middle of next year.
Now, another thing I wanted to touch on in my quest to spitball potential solutions to the communication problem. So one of the things that Ms. Schaake said in her video was that the information security community needs to get its act together. So the question here is, well, so one option there is, okay, let's try to have a funnel similar to like the cyber fast track or similar. The other question is, do we need potentially a trade association for small and medium enterprises in potentially Europe or worldwide that deal specifically with cybersecurity? And if we think we need that, how do we make sure that it doesn't turn into ISSA or similar? Any thoughts on that?
My only question would be, why is the focus on enterprise?
Well, when I say enterprise, I mean like small businesses and also potential individuals. So essentially, the way I see it is that the current landscape is you have big vendors, and they have their lobbyists and they have their own set of interests. Then you have certain trade associations like ISSA, and I think there are a couple of others, which supposedly represent the entire industry. But what I can gather is that they represent a part of the industry that does not include sort of like the researchers and the people that another way of splitting this is they represent the part of the industry that actually sort of like implements the day-to-day security policies and so on and so forth, but they don't represent the part of the industry that actually creates new products, that does research and so on and so forth. And my personal take, and I was discussing this with Paul before, is that especially when it comes to policy and regulation, you want to talk to the researchers and, again, the people that do innovation in the field, because they have a longer term view on things versus the guy that writes firewall rules. And so that's what I mean by trade association. I mean, and usually that sort of research is done by small groups, whether they are separate companies, groups of friends, or potentially small departments within bigger organizations. Do we need sort of like a trade association for those type of people? And if so, how can we prevent that from going bad and turning into an ISSA?
So I think it would be terribly useful to have some sort of organization that helps us have a voice in policy discussions, but it's going to be hard to pull it off in the sense that we're a very heterogeneous group, right? Within security, there is security vendors. There's the people that implement security in corporations, which are often, like, we have a friendly but adversarial relationship often with security product vendors. Then there's security researchers, which may or may not have any corporate backing at all. So any trade association, as you mentioned it, is going to be a difficult thing to pull off because you've got all these different interests in there. And also a lot of people that are capable of bringing money to the table may not actually be healthy for the organization, right? Because even within the security community, there's a lot of disagreement about what percentage of security products are actually useful. Haroon said something in his speech, something is turning into the next AV, antivirus, right? So he's using antivirus as an example of something that's horrible. Point being, getting these things under one hat and making sure that the money doesn't distort things is going to be tricky, but at least the policymakers would have somebody to talk to, which at the moment, I think if a policymaker is asked, hey, can you, like, we've got this policy proposal, call your favorite cyber expert to comment on it, most of them wouldn't know whom to call.
Yeah, I think that you're right. I think it will be very difficult to get one voice. So why don't you forget about getting to one voice? So just give a set of opinions. That's already a tremendous added value. I understand that many of these trade associations, they try to get to the consensus approach because they want to be really powerful, and you cannot. But okay, that's perhaps for another stage or for dedicated topics. But there is at the moment not even the possibility to get the diversity of views, which already would be very good. And then you will see that there's an immediate dialogue with policymakers. So I'm quite positive. If you avoid the bureaucracy around trade associations, because many of them become also bureaucratic organizations itself. And I think this community can be very good at that and doing that, because that's the way I think also here many of these events are happening. So that's one thing. The other thing is you will be in over demand. So there will be a tremendous demand for this. And the reason I say that is that we focus here perhaps on kind of general legislation, which is for all kind of IT technologies and all kind of sectors in principle. But I happen to see in my portfolio also the things around, for example, automated driving, energy smart grids, or digital health. And all these people are in tremendous need to get advice. Really, automated driving is running forward very quickly, and we, I think, are really interested. These are the big automotive companies who need to know where they're going to be in the field of security, IT security. Health is almost unexplored, and it's one of our risky environments. So there, I think there will be a lot of interest to interact.
So before we open it to questions, I want to close with one question for Regent Paul, which is, so personally, I think this applies to Thomas and to everyone else from the industry that has been involved in this process. We've learned a lot in terms of what it means to deal with policymakers, what it means to deal with privacy organizations, human rights organizations, and so on and so forth. The question for the two of you is, what else can we learn? Like, what have we messed up? Because The Privacy International example is a good one because if I recall correctly, and that doesn't apply just to Privacy International, it applies to a bunch of different privacy organizations. For instance, your stance on intrusion software changed, and I think during like the past few months, and I think part of it was our problem in the sense that we could not find a proper way to communicate what we were trying to say about intrusion software. Maybe it was not entirely our fault, but I guess my main question is, given that you guys have a slightly different background, what do you think we should do better in terms of dealing with your type of organization and your type of organization?
I think that's a very fair characterization. Our starting point was to limit the control, or to limit the spread of things like FinFisher and Hacking Team to repressive regimes. That was a starting point to advocate for what essentially is a very attractive and very effective mechanism in Wassenaar. You essentially get almost 40 states for free if you can convince a number of them to propose something and vote on it. Unfortunately, the text that was proposed, as many people pointed out from day one, that it was going to catch many things that would essentially undermine the privacy and security of the very activists that we were trying to protect. I think it took us time to assimilate the information that was coming at us, but I don't think that's necessarily the fault of the security community. This is there was many people emailed me out of the blue to offer their opinions, and I engaged with every single one of them. And it took time to understand what exactly was being said, and from our understanding of both export control law and the technology itself. So I think now that we're in this, I'd say, better position where we appreciate the nuances of IT security and the nuances of export controls and how potentially damaging it can be. I think I'd prefer to characterize it as more fault on our side than on anybody else's side, because there was a really kind of heartening and almost made the hairs on the back of my neck stand up when I saw so many people online with very, very meticulously thought out arguments that unfortunately just took us time to parse and go through.
Paul, any thoughts on this?
Yeah, I think perhaps two suggestions. One is that, of course, we build on security, privacy to existing technologies as an afterthought. So now with 5G, Internet of Things coming, at least we should do that a little bit better. And I think that's these are things that are important developments right now. And the other is, because you were saying that a lot of the EU legislation gets the interpretation at the national level, so you may have 28 different interpretations. One of that is around data retention, and you were referring to the case now being proposed in the UK. So it's quite important now, because also the data retention directive has actually been rejected by the Court of Justice, and so national laws are coming up now to follow that as a process very closely, so that we are certainly also avoiding that we get the kind of the wrong balance here between, for example, security and economic interest, to mention one of the consequences that can come out of that. So that's and that we get a whole patchwork of solutions. So I think it's an important current development.
So any questions from the audience? Yes.
So as you limit selling the products to regimes that could, let's say, abuse them, your competitors overseas that have no such governmental limitations, would you lobby the EU to forbid their products to be sold within the EU?
In other words, the products who fill the gap to, I mean, that's a policy question. It would sound very, very good, but that's why Wassenaar had a lot of potential, because it included a lot of the states. Obviously, China wasn't included in that. A lot of the states who would potentially be seen to be economic competitors, and that any tying of the hands of through a regulatory regime of, say, a UK company, and then you had a French company which could fill that gap by going through the Wassenaar mechanism, it would kind of neutralize, not completely neutralize it, but remedy that argument. The other thing as well we see is that a lot of countries, when they're buying their surveillance apparatus, I'm not sure it's necessarily purely along technical lines. It often falls along political lines. So if a country was looking to China to fill the gap of European companies that were coming along, because we follow the surveillance industry quite a bit, I'm not sure countries would necessarily trust that kind of technology as embedded into its national security apparatus. I could be wrong, but there does seem to be a little bit of a reluctance. Even in the UK, for example, BT, one of the big telcos, was looking to buy routers for its backbone. And there was a big outcry from the members of parliament, which said, no, you shouldn't be using Chinese technology in this. Huawei was the company. So I think I'm not sure it's quite as simple as, if we can't get it from this place, we'll go somewhere else. We did see IMSI catchers been rejected for sale to Pakistan from Switzerland. But as you say, I'm fairly certain they could find them somewhere else, and maybe as a stick to prevent that kind of circumventing of the regulations, maybe it would prevent that company from selling in the EU market. That might be good.
Sorry to interject, just to move on to the next question. I think the right question there is, there are a set of things that would require the cooperation of all the nations, or either that, or the other option is to say that we take the higher moral ground, we being Europe, the US, and so on and so forth, and we accept the cost of not doing certain type of businesses. If the former approach, so everyone agrees, worked, then the UN would be an effective organization, but we know it's not. And so the question is, do we believe that we have the means to take the higher moral ground when it comes to tech and human rights? At least that's the question I would ask myself. Next question.
Yeah, so at least in the US, like the healthcare market, you see innovation kind of grind to a halt very slow because of all the regulations around it. So when you add regulation into this very, industry, how are you going to create an environment where innovation can occur above the board in a way that is not hindered, it's not slowed down, it's open? How do you incentivize that in the case of regulation?
Yeah, I think that's a great question in terms of the both not only the actual, for example, red tape, but also in the chilling effect of people not engaging in the work in the first place. And that's why I think much of the language in, say, Wassenaar, or any of the proposed language in the EU and the national law, needs to make it extremely clear what is and is not regulated, to the point that an ordinary individual can read the piece of legislation and know it. And I'm not talking about legislation, I'm talking about like a paragraph which says, you're doing this, and it's not even an exception. So one of the things that Wassenaar tends to do, and a lot of export control law tends to do, is have this generic statement of the following is controlled in a prima facie statement. And then later on, you'll have to go in and find out if the work you're doing is subject to an exception. And so for things like vulnerabilities and things like that, we'd like to see the language tight so that there is no prospect of many of the security tools and vulnerabilities even coming within the language at all.
We have time for a question that should last no longer than 30 seconds. Anyone wants to attempt that? If not, thanks a lot to our panelists.
Thank you.
Please a round of applause and thank you.